Good day to everybody. Welcome to the candidate for the position of a judge, the Constitutional Court of Ukraine. Today, the advisory group of experts gathered to conduct an interview with a candidate for that position, Mr. Oleksandr Yurievich Vodiannikov, National Legal Advisory of the OSCE Project Coordinator in Ukraine. He was allowed to participate in the competitive selection by the Parliament of Ukraine. I will give the floor now to the Secretary of the AGE, who will be moderating the interview. So, Mr. Yaroslav Romaniuk, please, the floor is yours.
Дякую, пане голово. Вітаємо, Олександр.
Good morning, everyone. Good morning, dear colleagues, members of the public, and candidate. So I would like to say that all 6 AG members are present. AG Chairman Mr. Oleksandr, who is present online. Physically, we have in the hall Ms. Hanna Sukhotska, Ms. Maureen O'Connor, Ms. Natalia Kuznetsova, Ms. Oksana Vasilchenko, and AG deputy members are also in attendance, namely Thomas Griffith, Richard Barrett, Marek Zubik, Vasil Shakun, and Volodymyr Kuzmenko. Mr. Oleksandr, we will have quite a long period to accumulate information as for you. We are really grateful to you for your sincere communication and evidence-based answers to the questions. But according to the methodology, this is a mandatory stage of the interview, and its goal is to give you a possibility to clarify any doubts regarding your high moral qualities that are required for the position of a judge of the Constitutional Court of Ukraine. So we will ask some questions and we will ask you to clarify this information in the answer. Please note that in accordance with the methodology, the candidate may not provide information, documents, or other materials during the interview if the advisory group requested their provision earlier and the candidate did not provide them within the specified period, or if the candidate could provide them on their own initiative earlier. However, the advisory group may make an exception if it determines that such an exception is justified. Also, I would like to say that the interview is being recorded and streamed live on the AGE resources as well as the CCU website. Therefore, I call upon the AG members and the candidate to limit the use of sensitive data and limited access to information on live air. So if this happens, we will stop the streaming and we will communicate just in the hall. So I would like also to draw your attention to the fact that the duration of the interview is approximately 1 hour. The time limit for the response to question is 3 minutes. Please be concise and brief. Well, I really doubt that you do not possess English language, but if so, please use the headset because some of AG members are English speaking. So the blue light on your headset means Ukrainian channel. Also, at the end of the interview, the candidate may make a short closing statement up to 5 minutes. If it is clear to you, we can ask to start the interview. So the first question are from myself. Since 2004, you have been working in the following positions in the OSCE in Ukraine: Senior Project Officer, Scientific Advisor on the Rule of Law, National Manager of Programs, National Advisor on Legal Issues, etc. So it seems that you work on managerial positions and law positions. So please, what is the ratio between the managerial and legal duties? Thank you so much for your question. Here I would like to explain how the OSCE mission functioned. We have a mandate. So please be concise and laconic. You have 3-time limit. If we evaluate subjectively, it will be 50-50. Do you think that your legal experience is enough in the field of law to occupy the position of a judge in the CCU? Yes. Can you explain it? Well, I have a very interesting background. I have become a specialist in different spheres, including the constitutional law. I have practical experience to be involved in the proceedings at the request of the judges' rapporteurs. And also I worked in the Commission on the Legal Reform, and I provided consultations to the Parliament. Even now, I have been a member of the task force group on lobbyism, so my background gives me the reason to believe that I have qualification and scientific background to be present in this sphere. It is clear. Thank you. So, since 2012, the program coordinator of the OSCE in Ukraine has held annual summer schools on constitutionalism and the rule of law. And this is your sphere. Yes. These schools were held in different regions and lasted about a week. Yes, a week. And a number of researchers and lecturers from leading universities throughout Ukraine were involved in conducting lectures in schools. Some of them, tell us please, whether it was paid work. As a rule, we had 4 experts that we involved on the contract base. Other lecturers, they participated without payment. We covered the expenditures for their trips and dwelling. So contract-based experts, they were paid. So whether you a tax agent? No. Look, we use... So you were not. I can explain. Did you control and supervise the payment of taxes by the researchers on the income received? No. Do you know whether the lecturers paid taxes on such income? No, I don't have such an information. So you do not know, and you are not a tax agent, so you are not accountable for the tax payments of these peoples. Okay. I pass the floor to my colleague Maureen O'Connor, and she will ask you the following questions. So please, if you need, use the headset, and you will hear the questions in Ukrainian.
Good morning. Sir?
Yes.
Okay.
Yes, ma'am.
Are you comfortable answering the questions in English? You don't
Yes.
have to.
Okay.
You can use Ukrainian. Okay. Maybe I should tell you, you have to, and let's see how you react to that. Okay. In response to the questions that the AGE asked, dated January 24th, 2024, you indicated that during 2022 to 2023, you made a number of trips abroad, namely to the OSCE Secretariat in Vienna, the OSCE Documentation Center in Prague, the Office for Democratic Institutions and Human Rights in Warsaw. Is that correct?
Yes.
All right. I'm just going to briefly go over the amount of days that you, without necessarily using the dates at this point, but starting in June of 22, you spent 6 days in Vienna. In August of 22, you spent 25 days in Vienna. And in October to November, you spent 38 days in Vienna. And then that brings us to December. You spent 45 days in Vienna, December of 22 to January, the end of January 23. Then you also spent 17 days in Vienna from February 10th to February 27th, and then back to Vienna in April of 23 to May of 23, 14 days there. All right. That you recall that?
Yes.
Okay, great. Why did the development and approval by the Office of Democratic Institutions and Human Rights of projects related, in your words, to the mandate of the ambassador require your long business trips abroad, given the fact that under the legal regime of martial law, trips abroad of conscripted men ages 18 to 60 are strictly limited?
Dear Maureen, first, there is no connection between restrictions existing in Ukraine under the martial law and my activities in the Secretariat and other OEC institutions.
So you're saying
Indeed,
they do not apply to you?
they apply to me
In
because I am citizen of Ukraine and I am also subject to these regulations. At the same time, I am an officer of international organization. And the national government, the host government, is under obligation of the international law not to obstruct operation of international organizations' field presences. Therefore, each time my management want me to be in Vienna, we received permission for me to cross the border. So my crossing the border was agreed each time by the relevant authorities. I stayed in relevant OEC institutions as requested by my management. So this is the answer to your question.
All right, so your answer is that you had the permission,
Yes.
Instruction, I would say, from
Yes.
your employer, and that's how that was given. All right, describe in more detail your role during your trips abroad, which you made during the termination of OSCE Project Coordinator's Office in Ukraine and the launching of a new format of project cooperation between OSCE and Ukraine. What exactly were your job responsibilities during those trips?
Well, this is a very long story.
We'll try and do it in 3 minutes.
Yes, thank you, Marin. Just to encapsulate, yes. In June, our mandate as PCU, Project Coordinator Office in Ukraine, was not prolonged due to veto in the Permanent Council. Of course, we expected such developments a bit before, just because, international communications and all this stuff in Vienna. Therefore, I attended first in June, after the launch of war and introduction of the martial law, Vienna to attend the Permanent Council of the OEC, as reflected in the documentation you have and received from the third parties. And at that time appeared a very strong interest on the part of both organizations, and it was also the position of the Secretary General to continue, despite the veto in the Permanent Council, OEC support to Ukraine. And it was also a huge demand on the part of other delegations in Vienna, our allies, Ukraine's allies in Vienna. But the question was how? How to overcome this obstacle veto in the Permanent Council and continue OEC presence in Ukraine. Why? Because each decision in the OEC should be taken by consensus. Therefore, at the time there was no consensus due to the blocking vote of one of the participating states. This is one part of the task I had. Therefore,
so your role was to
advise.
Be a consensus builder?
No.
No?
My role was to advise my management on how to proceed.
Okay.
Also, when it was apparent that the office of the project coordinator should be wound up because of termination of its mandate, another process started related to, let's say, winding up the existing field mission in the country. And that also required some legal advice, quite extensive legal advice, communication with the relevant structures of the Secretariat and other organizations, and many mundane things to be done. Many things were done, of course, by telecommuting, no problem, but there were, of course, many, let's say, issues that can be done only in person. Just to explain, I think it's understandable that you may not have a Zoom meeting with ambassador, as simple as that, of some renowned country. Of course, those communications require presence. I attended Vienna Secretariat when requested. And why? Because on the 24th of February 2022, at the evening, and it is publicly available information, Secretary General issued an urgent instruction to evacuate diplomatic staff from Ukraine. Therefore, starting from that date, my management in 2022 resided in Vienna just because of security reasons. Compared, for example, with current situation when ambassador, special representative of the chairmanship project coordinator in Ukraine already permanently present in Kiev.
Okay. You mentioned that you have used technology.
Yes.
Zoom
Yes.
is the in the parlance of what we do. How would you estimate the ratio, the percentage of your technology use, Zoom use, compared to the type of activities that require your presence, physical presence?
During the visits or in general?
I'd say in general, because, well, I mean, you're traveling each month, practically. So let's go in a month. Let's take a month. What's it look like, Zoom versus travel?
To answer the question, I still need to delineate two situations. First, during the 22-20 first half of the 23, and ordinary situation. For example, right now. Right now, my ratio of use of IT technologies compared to physical attendance, maybe 60% IT use, 40% physical presence.
So you're still traveling to Vienna?
I expect to travel, by the way, because I have planned visits for this year as well. But
I'm sorry, would you repeat that?
Sorry?
Would you repeat what you just said?
I expect, because in my working plans, I have also a visit to abroad.
Yes.
For this year as well. Because we plan activities each year, and of course we provide, if exigencies of project implementation requires, then of course we include in our planned activities also visits abroad.
All right, so it is projected for the year that you will be traveling?
Yes.
Okay, all right. One of the questions is that, and you may have answered this, in July of 22, the project coordinator in Ukraine ceased. You mentioned that. And then the support program for Ukraine was launched only in November of 22. Are those dates correct?
Yes, that is correct, but Office of the Project Coordinator in Ukraine existed till 31st of October.
So you were not unemployed during that period of time?
No, I was employed.
You were employed?
Yes.
Okay. All right. So all trips that you made abroad were carried out for work purposes and were official business trips?
Yes.
Okay. Where did you live during your trips abroad? What were your accommodations?
Well, I stayed with my family. According to the information you have, my family now is in Vienna, starting from April 2022.
April what? 2022?
22, yes.
Okay. And does that, I guess my question is, the trips are very long, they're concentrated in Vienna, and you have family in Vienna. Your wife, correct?
And children, yes.
And then you have one or two children?
Two.
Two children, okay. So I guess, one of the things that I'm concerned with, and, we're concerned with appearances as well as maybe any actual wrongdoing. Would it not be reasonable for an outside observer to form the impression that you facilitated longer than necessary trips in order to see your family in Austria? So, in other words, were these trips established first with the primary goal of visiting with your family? And were they as lengthy as they were with that goal in mind, and the work was secondary? That's my question.
I would start from the last part, on secondary and the primary role during the visits. I would rather say that no, my primary role was related to business, because we understand what I understood was at stake at that time for the organization, for my direct reports from my management, and for the staff of our mission, because of course the situation was not easy, and indeed how to proceed our support to Ukraine, taking into account the circumstances, was very pressing issue. With respect to my family, let me explain several things. My family, I advised and I made everything to ensure security of my family. Therefore, my family left Ukraine on the 10th of February, before the war, because well, my calculations at the time before the war told that something might happen. Therefore, my direct duty as father and husband was to ensure security of my family.
Understandable.
But my family moved to Poland at the time. The plan was that if something happens, they remain abroad. If nothing happens, then of course they will return somewhere in the first decade of March back to Ukraine, and we continue our ordinary life. Happens what happened. Well, the worst scenario happened, of course. For the whole March, my family stayed in Poland, in Krakow, with my friends, and during that period we received many offers of help from our European friends, colleagues, who reside in Sweden, in Romania, in Luxembourg, in Slovenia, and of course from Austria. And when my wife called me and asked what to do, and of course my first reaction was, of course, Austria, because the chance that I would attend Vienna for my working period, for business, was much higher than the chance that I could attend, say, Sweden or Romania. They moved to Vienna in April, somewhere beginning of April. It should be some dates in my explanations provided, but somewhere in the early April, they arrived in Vienna. My first trip was in June, late June. And of course, this prediction that I made, because my secretariat, that is my employer, is located in Vienna, become true, because I annually, even before the war, several times attend Vienna for business trips, and of course, this information is available in my file. This is, in general, answer to the question. The question is whether I insisted on prolonging my stay in Vienna due to family reasons, as far as I correctly understand, so that to dispel this concern, I would rather say that my stay in Vienna was decided by my management.
Okay.
I can't simply stay just because. Because I need agreement. I needed agreement from the head of the mission for that.
So what you're representing is that there was a primary business reason for you to be in Vienna. You orchestrated your wife and children to move to Vienna, knowing that you were going to be a frequent visitor to Vienna, and that was You stay with your family exclusively when you are traveling in Vienna?
Yes.
Okay, all right. Thank you. Yaroslav?
Тепер наступні питання продовжую я, Олександр Юрійович.
I will proceed with the next question. Oleksandr Yuryevich, you as the person who's authorized to fulfill functions of the state, you have to fill out the declaration. No, as the candidate for the position. In 2021, in your declaration, informed about having certain amounts of national currency and foreign currency, both in cash and in a bank account. In 2022 as well, you did that. So if we correlate 2021 and 2022, we can observe not growth of these savings, but a drop, and a rather significant drop in it as compared to 2021. You had less funds by 50,000 euro approximately. Correction, just a second, you will. Tell me, please, how did you use these funds? Thank you for your question. Dear Mr. Yaroslav Mikhailovich, in my explanations, I explained that the difference was not so big. It was basically a 30,000 gap. And why? Because part of money I was transferred, they were not in cash anymore. And some of them were used to pay taxes, and that's a standard practice. And other part of funds was sent by my family in Vienna. My wife did have certain income as the entrepreneur, but they're still on her account. It's this money here in the Bank of Ukraine. So for life abroad in Austria and Poland, this money was used, and these amounts that I declared were used, the ones that I declared in 2021. And in 2022, it was also an unpleasant surprise for me, this divergence, because I was hoping that I control expenditures more thoroughly, but we understand that this was a very difficult period. So do we understand you correctly that your wife, as the subject of entrepreneurship activity, managed funds that were on her bank account? They are on her bank account because, as you know, in accordance with the banking regulation, in order to obtain access to funds, they have to be transferred to another account. And at the same time, these funds were obtained in November 2022. So before that moment, she had no other funds that she took, that I brought to Vienna. Apart from those you brought in Vienna, so you brought money to Vienna, yes, and what amounts? Up to 5,000-7,000 each time. Well, I can't tell you exactly right now. So you did not increase or exceed the limit that was set by the law on the, yes, currency operations. Yes, I know this restriction and I stick to it. It's 10,000 is the restriction without declaring. And if declaring if the amount is higher. Okay. Next question, Oleksandr Yuryevich, is as follows. In 2013, at that time, the President of Ukraine, Mr. Yanukovych, he appointed the judges of the Constitutional Court of Ukraine, Tupytsky and Kosminy. In 2021, another president of Ukraine, Zelensky, has issued an order by which he abolished the orders of President Yanukovych to appoint Tupytsky and Kosminin for the positions, and announced the new competition for those vacancies, which, in his opinion, were now free. You participated in this competition. The question is the following. You should have understood that in this way, the judges of the Constitutional Court of Ukraine dismissal was not in line with the Constitution of Ukraine, because the Constitution gives the exhaustive grounds for dismissal of the judges from the Constitutional Court. And later on, this was confirmed by the Cassation and Administrative Court, and also the big chamber of the Supreme Court that recognized it as illegal. So why did you, as an educated person, so I mean, you did understand the illegality of this competition and for these newly emerged positions. How can you explain this? Thank you, Yaroslav Mikhailovich. It is indeed a very interesting question, but it combines two different aspects. I would put them aside. So I would probably divide it into constitutionality and legality of the orders of the president, the right of the president to appoint the competition per his quota. Why? Because the question of the constitutional nature of the decisions, orders was defined by the Supreme Court, but the law on the Constitutional Court envisages certain terms, and these terms indicate the president is to appoint the competition before the moment before the dismissal. And from this point of view, the president acted in the framework of this provision, because the law does not define any other date when the competition to be held. The Constitutional Court quit this delicate situation in a very good way, so they waited until these positions were dismissed and selected the appointed judges. So, I mean, the process itself, the process of nomination and selection of these new judges took place correctly. But so you're saying that the procedure was within the law, and that's why you participated in this competition, right? And this was not related that in the constitutional, non-constitutional way, these vacancies were free. I see. Okay, Oleksandr Yurievich, I will ask my colleague, Madam O'Connor, to continue asking questions.
I just have a follow-up question on the question that my colleague just asked you. Was the litigation disputing the constitutionality of the dismissal of the two judges pending when you interviewed for this position?
No, dear Marin, there was no such litigation before the Constitutional Court.
No, not before the Constitutional Court. It was before the Supreme Court. The illegality of the isn't that the court that made the decision? The illegality of the dismissals.
I'm not sure when the case arrived at the Supreme Court. I can't say it correctly. I may be wrong.
Олександр Юрійович,
Oleksandr Yurievich, for the time of the competition, was there the decision of the Supreme Court? No.
At the time when the competition was announced.
Okay, I understand that the decision of the Supreme Court was not final. There was no decision of the Supreme Court for guidance.
Yes.
That's a fair statement, right?
There was no any decision on the matter.
Okay, I understand no decision, but was there litigation? In other words, the judges that were dismissed, were they gone from the Constitutional Court?
I'm not sure whether I have this information. I can't recollect exactly.
Was that an open seat? In other words, they were not filling their positions on the court because they were dismissed by the president. Correct?
I'm not sure I understand what you are asking, Maureen. At the time of the competition to the Constitutional Court, there might be a judicial proceeding attacking the decision of the president to dismiss.
Right.
There was no proceeding with respect to the decision of the president to announce a new competition.
I understand that was done step by step, and that was done correctly. If you just look at that in a vacuum, okay? But you also have the having a case pending challenging the president's action. And I just wonder, were you aware of that when you applied and interviewed?
I was not aware, frankly speaking, that there was a case.
Okay.
I expected that might be a case, of course, and definitely there was a case later.
Right, and then anything that was done in the selection process was invalid.
I wouldn't say that it would be invalidated in that specific case, because the subject matter of the proceedings before the Constitution or before the Supreme Court related to other issue, meaning, namely dismissal of judges, not the appointment or selection of new judges. Moreover, in both cases, the terms in office of both judges was to expire quite close to the competition.
Okay, so if the president had done nothing, their terms were going to expire anyway?
Yes.
Okay, all right. Okay, let me shift gears here, and I want to ask you about an article. May 24th, 2018, Oleg Sukhov's article, quote, "Reformer and Anti-Reformer of the Week," was published. In this article, you were named Anti-Reformer of the Week.
Yes.
The article states that the coordinator of OSCE projects in Ukraine, namely yourself, has repeatedly sided with the Higher Qualifications Commission, which is accused of falsifying the competition for the Supreme Court and plans to falsify the future competition for the Anti-Corruption Court. That you criticized the Public Integrity Council, the supervisory body of the Civil Society of Judges, which tried to prevent rigging of the competition for the Supreme Court. In an article last year, he said, many candidates don't deserve the Public Integrity Board's findings. He also stated that candidates would be the most honest judges. You claim that the competition for the Supreme Court was unprecedentedly transparent. Vodiannikov noted that the Public Integrity Council, quote, "does not have the right to evaluate specific judicial decisions of candidates, but only the judicial work of the candidate as a whole." He added that the board had a conflict of interest and should consider, quote, "making its ranks more ethical." What is your response to that article?
I published the response on the same in the same paper, I think 2 weeks later.
Okay.
I provided the reference to my response to these specific allegations. Also, I offered you for your attention a letter sent by my supervisor, Jeff Ehrlich, and why I'm sharing, because he specifically instructed me to share whatever I that addressed all these allegations that I still consider not justified and taken out of context. Moreover, in the article that was published a year before this specific anti-reform op-ed, I said a bit different thing. I criticized the High Qualification Commission, though I underlying their devotion and dedication to the judicial reform, their attempts to be transparent and accountable, but still unprecedentedness, as I referred in the article, does not mean impeccability. And that was my point, that there was a huge amount of things to be taken into consideration, both on the part of the High Qualification Commission and Public Integrity Council, and finally, Public Integrity Council was very receptive of this recommendation that was voiced not only by me, but other donor community, and finally, the Public Integrity Council became a very strong tool and very effective tool in ensuring accountability before the society of the High Qualification Commission and the procedures for electing judges, and so on and so forth. Therefore, for me, the publication of this op-ed was a huge surprise, I would rather say. And it was a very unpleasant surprise, because we, during years, supported the judicial reform in Ukraine. We did much to have this reform implemented. We also supported the establishment of the new Supreme Court, which Hanna Suchoyska, during our conference in Chisinau, said that it was a success story for Europe. And taking into account, for me, it was a huge personal blow.
Let me ask you some questions. So you're saying that statements. Excuse me. You're saying that the statements that were contained in this article were taken out of context and used in a way that gave the false impression.
Yes.
Okay. So you would not agree with the statement that you criticized the Public Integrity Council?
Yes.
That's not a true statement that you criticize them, even though it's okay. And you just answered that the role of the Public Integrity Council is to ensure accountability across the board to government operations, government entities.
The selection process and operation of the High Qualification Commission, that is the government authority.
The commissions, the task forces, whatever is a body that's making a decision.
On judicial appointments or vetting judges.
It's just there for judges?
Yes.
Okay, all right. So you did not say that the board had a conflict of interest and should consider making its ranks more ethical?
If you read the article that I published, of course it was in Ukrainian, it was a year before, my point was that even the Public Integrity Council should ensure some ethical standards of its operation.
Okay.
Because for outsider, it would be a question how Public Integrity Council manage their conflict of interests. And of course, for that purpose, we need some kind of guidelines or instructions that were not existent at that time. So it was an advice.
Okay. So you were advising them for their own operation
Yes.
and for the public viewing.
Yes.
So the public can have more confidence in what they're doing, set some standards for yourself
Yes.
and comply with them.
Yes.
Okay, that's fine. Do you consider the competition for the Supreme Court to be transparent?
Yes.
You don't have any problem with the role of the Public Integrity Council in the operation of the selection?
Well, again, in that specific article, this op-ed referred to, I made a strong statement that the High Qualification Commission, when it did wants to dismiss the opinion of the Public Integrity Council, a specific judge or candidate for a judgeship, should provide clear justification why it disagrees. Because it is statutory authority of the High Qualification Commission to disagree. But this disagreement should be justified. We understand that the workload of the High Qualification Commission during that time, sometimes this collegial body have no opportunity to spell out its position, why it disagrees with Public Integrity Council. And this was a very substantive drawback of that process. That goes without saying, because many decisions of the High Qualification Commission of judges were quashed by the Supreme Court just because no sufficient justification was provided.
Okay.
And that point was raised even before those processes started in that article.
All right. All right, the last area that I want to inquire is in your scientific work, in particular in the work of, quote, Gender Equality Theory and Practice in Comparative Constitutional Law, dated April 20th, 2021, and in scientific report in the collection Mariupol Constitutional Forum, quote, Human Dignity and Ensuring Human Rights in the Conditions of Social Transformations, from September of 21, contains quite similar theses. Thus the sentence, quote, equality in modern constitutionalism appears in at least 4 interrelated qualities: equality as a constitutional paradigm, equality as a principle, equality as a right, and equality as a component of other constitutional rights and freedoms, close quote. There is a similar quote in the work, quote, Gender Equality Theory and Practice in Comparative Constitutional Law, on page 50, and in the scientific report in the collection, as I mentioned, the Mariupol Constitutional Forum, Human Dignity and Ensuring Human Rights in the Conditions of Social Transformations. You say equality in modern constitutionalism appears in at least 4 interrelated senses: equality in constitutional paradigm, equality as a principle, equality as a right, and equality as a component of the constitutional rights and freedom. Essentially what you said in one article, you said in the other article. Further, in the work Gender Equality Theory and Practice in Comparative Constitutional Law, there is a thesis, very similar. The constitutional paradigm of equality requires not only equal civil rights, it is aimed at protecting against the majoritarian fate of democracy. And the same thesis is found in a scientific report in the collection I mentioned already, the Mariupol Constitutional Forum. My question to you, wearing your academic hat, all right, does using the same theses in different scientific papers violate the rules of academic integrity?
I don't think so. That this specific reference.
Okay, I'm gonna relate it to self-plagiarism. That's the paradigm that you're going to be looking through for this work.
I understand. The Mariupol report, the Mariupol Forum report, it reflects what have been said during the event.
What has been said by whom?
By me.
By you, yes.
By me. What have been said by me. And for the presentation, I used the results of research done in the book you referred to. I mean, the Gender Equality and Comparative Constitutional Law, Theory and Practice. So that to advance these specific ideas. During my presentation during the first Mariupol Forum, I made these all statements so that to advance this idea. When I was asked to provide this thesis in writing, I provided what I was saying during the event, based on the work of the Gender Equality in Comparative Constitutional Law.
Okay, you said it, you own the words, nobody disputes that. My question is, when you used it, after you spoke it, and then you reduced it to writing, and it was used in various articles, correct? Should you have attributed that with a footnote to make it clear the origin of the 4?
As far as I remember, I may be correct, but I need to check. I have a reference in this specific paper of Mariupol Forum to this previous book on gender equality.
You think you've done that?
I usually, when I refer to my previous work, I made a relevant reference.
Okay.
So
Alright.
if you check other my works, you would find the reference to my previous
so
work, just
you-
because
You do
yeah.
quote yourself quite a
Yes,
bit.
not quite a bit when relevant.
I know,
more
I put words in your mouth. Okay. But had you not, let's just say for argument's sake, we'll go back and check, but for argument's sake,
It would
if
be
you did not
suspicious.
use your, your reference, would you say that that rises to the level of self-plagiarism?
It would depend. It would be suspicious.
Okay. All right. All right. Thank you. Thank you very much. I have no further questions. Vladimir?
Шановні колеги,
Dear colleagues, are there any other questions from the AGE members? Please, the deputy, Mr. Volodymyr Kuzmenko. Thank you. Preparing for the interview, the AGE provided a couple of requests, and I would like to return to the block of questions from Ms. Maureen about your trips. Your official request that we said that they say that since the June 2022 to the April 2023 you were on business trips, and if we count in general that this period includes 10 months, so this is like 300 days, and out of these 300, 145 days you were in trips, so the half of this term. You said that your presence in these business trips was related to the necessity of collaboration and communication with people that are there in these places. Not only, but yes. And we see here that the chairman of our AGE collaborates with us in Zoom, so you think it was impossible to do. There are some events. It's a very good question. Please answer it. So again, 145 days. It depends on the typology of event. It depends on the meeting with whom. For example, if with Mr. Alesh we can meet in Zoom, it is a very good thing. But there is a category, a full group of persons and officials with whom such online communication are not plausible, or they do not agree. So these are high-ranked officials, like head of delegations of big states and countries, etc. Also, a lot of things needed to be clarified, and there were some consultations that I needed to provide to my management, and my management, senior management, thought that my competences and my experience were needed there. That's why I do not disagree, and I have never disagreed to the instructions I obtained from my management. It's very good, thank you. Then I will continue. And maybe you will remember which meetings you had to hold with people in physical presence. For example, from the 14th of December to the 28th of January. So it's like you see the last 2 weeks, Christmas period and then New Year period. So this is the longest, your longest trip, 45 days. And due to the fact that returning, so the return to work of these categories of people cannot be foreseen because these are different categories. That's why my senior management, they didn't insist on my return to Ukraine during this period, and they thought that as soon as the diplomatic season starts in Vienna, I should be there. So I haven't understood. So being 45 days there, it means that your senior management didn't insist on your return. No, you asked whether I was during the New Year period. No, I asked what your activities should be done in this year. Because, for example, this year again, we will celebrate Christmas in other time frameworks as it had been before. But we know that in such countries as Poland, Czech Republic, the last 2 weeks before the new year, this is vacation period, like Christmas period. And you indicated being in Prague and Warsaw from the 14th of December to the 28th of January. Yeah, destinations are indicated just to show that periodically I was present not only in Vienna. It doesn't mean that probably in these days I was in Prague or Warsaw. If I can answer like this, yes, in Prague and in Warsaw we have institutions where I performed correspondent tasks and duties from my management. So it was necessity like to commute in between these cities, and you had to perform your functions. Yes. Are there any other questions? Mr. Marek Zubik.
Chairman Alizara allows me, I would like to ask you a more general question.
Yes, please, Marek. Please do it.
The Act of Constitutional Court requires a candidate for a judge of this court to demonstrate high moral qualities. Please explain me, how do you understand this concept? In particular, I would like to know how you interpret the word high. Who or what is the reference point? From whom are ordinary moral criteria required? From who the higher and the highest one? And every citizen, public officials, judges of common courts, maybe someone else. How do you understand these requirements?
Thank you, Marek. And to answer the question, I would rather point to the practice and that exists when selecting judges of the European Court of Human Rights, also, because Article 24 of the European Convention also provides for a high moral character for the candidates to that highest position. And for years of existence of the advisory panel for selecting judges of the European Court of Human Rights, there is already certain standards set by that panel during the years of their functioning that is published in biannual reports of that. And that includes, among other things, several criteria. Yes. First, absence of
Sorry, if I may once again to ask this question. Who or whom is the point of reference? You shouldn't be described this criteria.
Oh, okay.
But who is the point of reference? Who is common level, higher level, in the highest level?
Well, the wording says of the high moral characters, as far high moral character, as far as I remember correct. Therefore, the difference is between general and high. I assume. What
can check, but if I may ask once again the questions. What is the reference point? Who should have common moral qualities, higher qualities?
You mean what moral qualities should possess a person for a position of a judge?
Constitutional
High
Court.
moral qualities.
Mm-hmm. This advisory group of experts should recognize if you have
Yes.
high moral qualities.
Yes.
But I'm asking you, in your opinion, what is the point, reference point? Who has represent common standard of moral qualities?
If I
we can agree that
understand.
it's any level or for every citizen any moral qualities or not?
I would rather recommend to look at the existence or absence of information compromising the specific person in terms of moral qualities. because, you know, high moral quality is a value judgment, usually, because we perceive a person either of high moral quality or low moral quality based on the experience. When we are selecting people whom we do not know, of course, we rely on general objective criteria, whether we have information or some signs that the person may not meet the high moral quality standard. At least when I'm hiring a person for the position in an international organization, and I meet the person for the first time, of course, studying his profile, he submits. For me, it's important to understand that there is no negative information behind, and I presume that the person meets moral quality necessary for work in an international organization. I can't say that you can provide some objective criteria for high moral quality, and for that purpose I refer to the position of this advisory board, advisory panel for selecting of judges of the ECHR, because they're also facing this dilemma how to assess moral quality of those people who are submitted for election in the court. If I correctly understand your question.
According to you, there is public morality. Is it something objective or this not?
It's a matter of perception, I would rather say. How?
What's your perception?
What my perception
Yes.
of what?
Do you believe there is something like else more public moral, especially due to European Convention of Human Rights or something like this?
There is such notion as public morality as a grounds for restricting certain rights.
It means that something is objective, public morality.
Even the European Court of Human Rights is quite at pains to recognize that there are some such objectivity in public morals.
Okay, thank you.
Ще запитання? Немає?
More questions? I have a question. Please, Vasyl Ivanovich. You know, I want us to go back to your wish to become the judge of the Constitutional Court. And it seems like this is the second time that you run for this position that is very honorary in Ukraine. And I have two questions for you. Question one, since you prepared as far as I understand, so question one, could you tell us when, for the first time in Ukraine, the idea was implemented of the Institute of the Constitutional Control? That's question one. And then I will ask question number two. Thank you, Vasyl Ivanovich. As the member of the advisory group, I suggest you answer the question of my deputy. Okay. Give us this, it's 1990. The idea of the constitutional control? No. When was the constitutional control implemented in Ukraine? 1996. Constitutional court and constitutional control, these are two different things. Vasyl Ivanovich, I would kindly ask you to consider that this interview is on the high moral qualities adherence to. I speak about moral qualities. Let's limit our interview only to questions that refer to it. Okay, I have another question then. A follow-up question asked by Mr. Marek. In which document the requirements for the judge of the Constitutional Court are formulated, and could you list them? The requirements for the constitutional judge is formulated in the Article 167 of Ukraine, and it envisages the citizen of Ukraine who's up to 40 years old, who has the experience of work in the sphere of law not less than 15 years, has high moral qualities, and a well-recognized level of competence. I see. No other questions? In this case, Oleksandr Yurovich, we give you the right to have the concluding remarks. 5 minutes, please. Okay, thank you. I would like to thank you, dear colleagues, because not so often you get to talk about yourself for 1 hour in front of a very honorary audience, and indeed this is very pleasant. But I also would like to express gratitude to that part of people who organized this competition, to the secretariat of the advisory group of experts, because I see how dedicated they are. I got inquiries at 10 p.m. and I understand that people are very carefully treat this task that is to provide efficient selection of the effective selection of the candidates. So I would like to inform them that I'm impressed by their work. As for this competition, I wish you success in this important task, because we are in the midst of the situation that when this success or failure
or failure for all. Я впевнений, що це знову ж таки.
And I'm convinced it's either going to be a success or failure for all. Thank Oleksandr Yurovich for your answers. And I announce the interview with Vodiannikov Oleksandr Yurovich interviewed over.